SOMAYAJULU గారి ప్రసంగం ప్రవాహంగా సాగింది. ఆనకట్టలేని ప్రవాహంగా సాగింది. Really, it's a feast to the ears. Starting from where SOMAYAJULU garu has left, and before I begin to touch the topic of the session, why SOMAYAJULU garu is so successful? He has many good traits. One is the confidence with which he acts. And the confidence is the key. Which I noticed when he is speaking. How this confidence comes. When I joined the bar, I did not even complete a few years at the bar. I was still the baby at the bar. Even for asking an adjournment, we used to go prepare to district courts. Even to seek an adjournment, we used to go prepared. What happened once? I was Justice, I think, Narasinga Rao was our judge then in Kakinada courts. Other side, an eminent senior, the farmer developer, Alapati Krishna Rao garu was this advocate. Both my seniors are my respected father and respected brother are away. I was asked to seek an adjournment. Then we prepared an adjournment petition because already the case was adjourned twice for various reasons, though for our asking. Then I have gone through the brief. And as usual, when I sought an adjournment to take advantage, the other side opposed. Then the judge was furious. Already the case was adjourned twice. This is the third time you are seeing adjournment. Instead of saying what's there in the adjournment petition for adjournment, I said the crux of the case is this. We are relying upon a will and adoption. In which the testator decided that I am the adopted son of the testator and bequeath his properties to my claim. The only contention is that the adoption is not true. Even that contention is to be accepted as the person designated under the will. Therefore, I am entitled to the properties. This is our case. Therefore, we need some time to get the understanding. I thought it is better to present a few facts and then seek an adjournment. Another instance I tell you, not for judges' years. One of my uncles was a very senior practitioner. He walked tall in the corridors of the courts at Kakinada, an eminent senior. One judge, by his nature, was averse to granting ex parte orders. In that particular case, he wanted an ex parte injunction. It is highly essential. The misfortune of the claim, he could not get some documents, but the order is urgently needed, otherwise by the next day he may be disposed. So with a few documents available, the case was filed. How to get an injunction from such a judge? Then he also prepared an application for appointment of a receiver along with an application for seeking injunction. Then he started first arguing for appointment of a receiver. So persuasively argued, then after see score marks, even before judges. Coming to the topic. I thank the organizers, President and members of the Bar Association, the London District Judge, and particularly my friend SOMAYAJULU garu for giving me this opportunity to share my humble thoughts with all of you. As we all know, economic offences are a separate category of offences. Undoubtedly, they inflict pecuniary losses, sometimes to the individuals and many a time to the nation. The offense of smuggling of narcotic substances counterfeiting currency and valuable securities, financial scams, frauds, money laundering, hawala transactions, stock market manipulations, corruptions and bribery amongst public servants, foreign contribution manipulations, evasion of taxes and duties, illicit trafficking of various kinds of contrabands, trade in human body parts, bankruptcy, racketeering in illicit arms, so many kinds of offences. And drug peddlers, they do this not only for material gains but also in all aspects. What are the determinants? Think of economic offences which are relatively of a lesser gravity, like theft, cheating, fraud, false travel documents, etc. Then our attention generally goes to closely related aspects like poverty, social exclusion, wage and income inequality, cultural and family background, level of literacy, sex and age of the offender, and other social factors as the determinants. Sometimes all these factors or some of them affect the individual's propensity to the crime. But when we look at the larger canvas, look at the offences at a greater plane, like I have already mentioned, the terrorism, fanatism, racketeering in illicit arms, trafficking in explosives, theft of intellectual property, stock market manipulations, smuggling, money laundering. Then we think of these offences, we are prompted to look at other factors, not mere social and economic factors. So when the thinkers devoted their attention, they also included two more factors. One is demographic, the other is esoteric factors. Demography is a study which is associated with population and the structure of population and the different age groups that make the population. Like for example, how people of a country get attracted to terrorism, join groups of terrorists, join groups of fanatists, then they join the groups of radicals. Otherwise, they become victims of drug peddlers. So they target on a particular age group of citizens, sometimes senior citizens, sometimes teenagers. Coming to esoteric factors, the esoteric factors are associated with groups. See, a terrorist means he is a person from a group of terrorists. Their means and ways are obscure, mysterious, impenetrable, and they repeatedly commit these offences. They have a ploy after ploy, and they always are lucky. They lie in wait, and then they attack groups of people, properties, and commit serious offences resulting in fatalities and casualties. the damaged properties. So their means and ways are cryptic, impenetrable, and they change with the times. Therefore, when we look at these offences, we need to update our laws. The penal provisions in the IPC sometimes may not be sufficient to deal with these offences, which are very, very grave. So, the framers of the laws thought it fit to introduce many legislations. Recently, the Prevention of Corruption Act was amended. Foreign Exchange Management Act was brought in being. Then we have now the act dealing with the fugitives. The law says that it deals with people who commit crimes where the value of the property or the money is more than 100 crores. It applies to only those offenders where the money involved is 100 crores and more. Who is a fugitive then? A person who has committed crimes, bank frauds and any other economic offence, and against whom a warrant is issued. He might have left the country after the warrant is issued and they refuses to return, or after he left the country, refuses to come back after the warrant is issued. Then he can be declared as a fugitive, provided other conditions laid down in the provisions of law satisfied. Then the only way we can prosecute such a fugitive, because when the law snooges, and the law agency, and enforcing agency also snooges, the accused runs away. Then how to get him back? Only by asking the other country where he is taking shelter to send him back, deport him to our shores. Then we have to see the extradition of laws and ask that country to send him back to our country so that we will charge him and prosecute him after a good trial. He will be convicted if he is found guilty. With some countries we have treaties. Where there is a treaty, then we make a request, there is a process for that, and then after the process, if the country agrees, he will be deported to our shores. Even in other cases where there are no treaties also, the extradition is possible. The fugitive can be extradited. This is also possible. Then, simply because there is a treaty, there is no guarantee that the fugitive will be sent to our shores. For example, we know Abu Sagan. He committed some offences dealing with illicit possession and importing arms and possession of the arms. He was associated with the famous model Monica Bailey. Then he was taking shelter in a country, Portugal, if I remember right. Then we wanted him to be sent to our country so that he can be prosecuted. Then a request is made. Then before he was sent to our shores, an assurance was sought from our country. Then our ambassador in Lisbon was asked to give the assurance. What was the assurance given? He will not be prosecuted for offences other than those for which the extradition has been sought. The second one is, he would not be extradited to any other third country from our country after he reaches our shores. Then he was brought back. The trial judge, because the facts are similar, framed several charges. Some of the charges are under section 3, 5 and 6 of RADA. One charge is under Explosive Substances Act, and then one charge is under the Arms Act. He contended that if he is prosecuted for these offences, he is likely to be convicted with the and is likely to be convicted, and the punishment would be, if he is convicted, death sentence or life sentence, and it is contrary to the undertaking assurance given by the ambassador. So he cannot be prosecuted for the offences other than for which the assurance is given for prosecution. Then he files a petition in the trial court for discharging for the other charges. It is dismissed, saying that we are now not punishing you, we are only charging you. We may not give you the punishment of death or life sentence, we may give you other sentence also. Therefore, you can be prosecuted. The matter goes up to High Court and ultimately to the Supreme Court. The Supreme Court also affirms the order of the trial court. Then he goes to the High Court of Portugal. The court says no, it is contrary to the assurances given. That was not the understanding when he was deported from our shores to your shores. Therefore, the authorization granted for extradition ought to be terminated. Then what to do? The matter again comes to our Supreme Court. Then the Supreme Court examines the whole issue. There are, of course, views that the judgment of the Portugal court is not binding on us. Then the available options to the Union of India are to approach an international forum to settle the divergent views, or through diplomatic channels have a reconciliation. But these two approaches are time-taking. Then the Supreme Court said, we will follow the rule of Committee of Nations. Even if we agree with the judgment of the Portugal court, though it is not binding, he can be prosecuted for the other offences and can, if possible, convicted. So we will allow this plea now at this stage. We will reconsider our earlier view. And then the Supreme Court said he may be prosecuted for the charges for which the assurance is given and not for the other charges. This is one case. Another case is Charith. He is a Sikh community person. He was prosecuted for certain offences committed in India, writings, and he used to be prosecuted for certain offences of writing and other serious criminal acts. He leaves the country. Then when extradition was sought, it was refused on the main ground that he will not have a fair trial in India. So this is the perception some of the countries, other countries are having about the trial system in our country. Even though in that particular case, there are certain peculiar facts which led that country to think that if he is brought to India, he may be lynched to death by certain mobs. So extradition request was refused. Now we know the famous case of Alia, the liquor baron, formerly the monarch Kingfisher. Now he also preferred an appeal, and his extradition was ordered for a UK court, saying that if he is reported to Indian shores, he will not have a fair trial. He is also relying upon the same case which I mentioned, and the matter is now pending in the Supreme Court in UK. This is broadly about the fugitive act. Then Prevention of Money Laundering Act. We look at the very name of the act, laundering. We talk our day-to-day example. If we get our clothes soiled, what we do? We send them to a laundry, get them cleaned up, and then clean them back. So slush money will be laundered. It will become good money. So every day, because of the money laundering or foreign exchange violations, 5 to 6 trillion dollars of money will be going out of the country, is the estimate. Then coming to this Money Laundering Act, what is the offence of money laundering? And by the methods of laundering money under the which are prohibited. So suppose somebody in a bank fraud makes huge money, no doubt that money is earned by committing a crime. It is a proceed of a crime. Then the question is, if he is charged for that offence and before he is tried, the money is attached, and eventually he is evicted, is acquitted, then whether he can be prosecuted and the money can be, attached money can be confiscated by the state. This is a question now which is now pending before the Supreme Court in one of the cases. The question is whether he should be first prosecuted and convicted, then only he can be proceeded against under the Money Laundering Act, and the money can be confiscated if only he is convicted. Like for example, take a case. In a public servant amasses wealth. Say he or she amasses wealth. The spouse of that public servant, knowingly that the money is a slush money, not a legally earned money, helps him in concealing that money. Or he or she is also actively involved in possessing that money or acquiring assets with that money, or uses or projects that money is not bad money but good money, then the other spouse also comes into the definition of this money laundering. The question is whether the spouse who is not a public servant can be prosecuted. This is also an area, grey area, which is yet to be answered by a court. There are many views. Some views are that she can be prosecuted because the money is a proceed of a crime. But is the allegation sufficient, or is it necessary that her husband should be prosecuted and convicted? Supposing he dies even before he is prosecuted, supposing he is acquitted, so these are the questions which are now bothering the investigating agency. They say this is about Money Laundering Act. Then coming to Foreign Exchange Management Act. It's only a regulation of money coming in and going out from India and into India. This Act speaks on who is a resident Indian, who is a non-resident Indian, who can deal with the foreign exchange, what are the requirements for holding foreign exchange, what are current account transactions, what are capital account transactions, and whether a foreigner can own properties in India, whether an NRI can own properties in India, if they can, what are the limitations, what are the requirements they have to follow. And then what is the role of Reserve Bank of India in regulating this foreign exchange. These are broadly the areas with which the Act deals. When we go to the definitions, the important definition is person who is a resident of India. Section 2B. A person residing in India for more than 182 days during the course of preceding financial year is a resident Indian, but there are certain provisos. Similarly, if the person is not excluded in this resident of India, he is automatically an NRI. Then who is a person resident outside in India? That means a person who is not a resident of India is a person resident outside India. Then the most important thing is the provisions of this Act are being amended every year while amending the Finance Act. The question is whether the amendments in this Act can be carried out without amending this Act and by amending the Finance Act. Now, a group of activists are intending to challenge this method of amending one enactment by amending another enactment, introducing amendments into one act while amending the other enactment. This is about foreign exchange management. Then coming to Prevention of Corruption Act. Drastic amendments were brought about in the recent amendments. In the year 2018, the assent was given by the President on 26 July 2018. We generally find three kinds of offences under the Prevention of Corruption Act. One is taking bribe, the other is disproportionate assets, the third one is public servant repeatedly doing favors to a particular individual or a concern. In these amendments, earlier, an investigating agency can conduct a preliminary inquiry before a case is registered. But when we read section 17A now, it reads inquiry, investigation by an anti-corruption agency including CBI NDA against a public servant in matters relatable to discharge of his official duties can be with the prior approval of the center, state or the disciplinary authority as the case may be. So even without prior permission of the authority, inquiry or investigation cannot be conducted. This is 17A newly introduced. But recently the Delhi High Court is yet to be reported. So he mentioned briefly in bar and bench, held that the agency is entitled to investigate in matters where the investigation is or the inquiry is not related to official duty. Then, when we read the penal provisions 7 and 8, the amendment therein, now we find, in my humble view, subject to opinions of jurists, the third category offence is not there in the amendment. Only the first two offences. Right taking on demand, then disproportionate assets. But repeatedly helping, doing favors to an individual for a concern, using advantage of the position he holds as a public servant, I think is excluded. Earlier, if a public servant who is to be prosecuted under the provisions of this Act is to be prosecuted, permission is necessary from either state government or central government or the disciplinary authority. So what the investigating officers were doing, they are waiting for a public servant who is on the verge of retirement to retire, and then they are filing charge sheets saying that permission is not required. Now the Act is amended, making it clear that even in case of a retired public servant, the permission is necessary from the competent authority. Another important amendment is the special judge shall complete the trial within 2 years. In exceptional cases, for reasons to be recorded, the period of trial can be extended up to 4 years. So ultimately, as we see, the amendments made the enactment public servant friendly. Because the decision making power is with the state government or central government or the disciplinary authority. Even a preliminary inquiry cannot be conducted without permission. The third category of offences is now doubtful whether it is still on the statute book. Then a retired public servant, if to be prosecuted, the permission is necessary. Then, in all these penal laws which we are discussing, there are presumptions. Now, because if a terrorist commits an offence, how to bring him to book? So the investigating agencies and certain whistleblowers and persons concerned with the national safety at various levels are advocating that why not make confessions admissible? As we all know, confessions made to police officers are inadmissible. unless they are associated with some recovery. The argument is under certain laws like forest laws, a confession made to an officer who is not a police officer is admissible in evidence. Why not a confession made to an officer of an investigating agency? Another argument is regarding presumptions. Presumption will not be drawn without any basis. As we all know, what's a presumption? Presumption is an inference drawn on the basis of proved or admitted facts. So the prosecution agency necessarily has to admit certain things, or the accused on the other hand has to admit certain things, or in the alternative, the prosecution agency must prove certain facts before the prosecution agency asks the court to draw a presumption. So what is wrong? That is the argument. So because they are finding it difficult in these grave offences to get the evidence which the courts accept as admissible evidence, they are advocating two views. We will also have the presumptions which are not rebuttable when certain conditions are not satisfied. Secondly, we will also have confessions as admissible evidence. For youngsters here, my talk is always to the youngsters because I know that all the seniors are very learned. We know that the difference between, for the youngsters, the difference between a confession and an admission. To tell you very simply, by quoting an example, the cause of death is drowning. One person says, I saw the victim drowning. Another person says, I drowned the victim to death. I saw her drowning is an admission. I drowned the victim to death is a why the second statement contains inculpatory statement on which he can be convicted. But what is the use of an admission? Is the admission useful to the prosecution? Yes, because he is admitting the cause of death, his presence, so and so died due to drowning. So many facts are admitted which need not be proved, because the Law Evidence Act is the same for both civil and criminal laws. So admission is the best form of proof on which one party can rely always. So they say that the confessions also can be placed on a higher pedestal in these economic offences. Another argument they advance is most of these offences, the evidence is digital evidence, electronic evidence. When the trial is complete, how many kinds of evidence will be before a trial judge? How many kinds of evidence will be before a trial judge? Only three kinds. Oral evidence, documentary evidence, material evidence. These are the three kinds of evidence. So far as oral evidence, there is no problem. It is common everywhere, be it in academic offence evidence, trial or the regular trial. How, on what matters oral evidence will be given?
Perceived by senses.
Very good. Facts perceived by senses. Drusya, Sravana, Sparsha, Rasa, Gandha. These are the senses by which the witness perceives particular fact. Then he deposes, all right, no problem. Then documentary evidence. Documentary evidence also no problem when it is primary evidence. Say for example it is a computer. The computer is produced. A cell phone. A cell phone is produced as a piece of evidence. It is primary evidence. No problem. Then comes the secondary evidence. In the matters of electronic evidence, we can call a particular piece of evidence as a primary evidence if only certain conditions are satisfied. What are the conditions to be satisfied? The instrument receives an input of some sort by way of a local file, mouse, keyboard, or through a communication channel such as a network connection. So it must be capable of receiving an input. Then it must be having the capacity to process the input. Then it must be capable of producing an output to a local file or a printer, for instance. Then it must be able to store the information. Then it must be able to control all these sequential events. Then it is called a computer. So cell phone is a computer now. If cell phone is used in the process of commission of a crime, it is seized. It is primary evidence. Because it has all these features. Then the question is secondary evidence. How to make a particular piece of secondary evidence admissible. Supposing it is a bank fraud. The computers are in the custody of the manager of a bank. We cannot bring all the computers of a bank to the trial court, and they cannot be marked. Because when you examine deeply this system of electronic evidence, an Excel sheet maintained by the bank, the one page of information, hard copy, will be stored in not less than 200 servers, not one server. Even though they are the local servers, it is difficult to bring before the court all the servers. So we bring the information in the form of a pen drive, CD, whatever it is, transportable digital evidence. Then what is the requirement? Certification by the person who is having control of those computers and servers. He says that the information published in a CD or a pen drive or DVD or even a cassette is not tampered, it is not fractured, it is genuine information. He is having control, he will certify it. Then the question is, most of the investigations, such evidence is produced without a certificate. Then we know the matters went up to Supreme Court. State versus Muhammad Afzal, 2003, Delhi Law Times 385. State versus Navjot Sandhu, 2005, 11 SCC 600. Parliament attack case, it is reported in Manu Patra, Manu DE 1026 2003. Anwar versus Bashir, AR 2015, Supreme Court 180. These are the cases which discuss this 65B extensively. Ultimately, in Anwar's case, they said production of a certificate is necessary. But as I said, in most of the cases, the investigating officers, because the law is new, did not produce certificates. Then the question came up whether a certificate can be produced subsequently. Then the Delhi High Court said, yes, it can be produced. Then one of the Honorable Judges of the Supreme Court, because there is some confusion for the trial court judges, wrote a wonderful article in SEC Journal. It is, I think, in 2015, page 1, Justice Korean Joseph, retired Honorable Judge of the Supreme Court, clarifying that the certificate can be produced later, and he also referred to the judgment of the Delhi High Court, while extensively dealing with his own judgment in A. Canvas case. Then the question now is, another two-judge bench, that is one of the Honorable Judges, Justice Lal Nageshwara, said that this question is to be examined by a larger bench. Now the matter is before the Supreme Court, whether the certificate can be produced subsequently or not. Possible, I will give you that citation also. So now the question is for the trial courts how to go about. There is so many emails. He also uses his cell phone. So many WhatsApp messages. Who will certify? The accused will not certify. Investigating agency will have to get a certificate. From whom will they get this certificate? The accused cannot certify that he is maintaining his computer before. Then the information is manipulated, fractured, or fabricated. This is the difficulty the investigating officers are expressing. In fact, this section 65 A and B, we have copied from a foreign law. They found that this section is not comprehensively well drafted. They moved forward, they removed this section from the statute books. But we are still continuing with the same doctrine which the other countries which first introduced this section not suited. Then the other question is whether it is necessary to examine the person who issued a certificate. It is also not resolved. Some courts said not necessary, some courts said it is necessary. Then about servers. Supposing Google server is used. These servers are not within our territories. They are at places away from our shores. They are not giving any certificates. And some are virtual servers. They only pass on the message but don't store the message. Now you see, for example, the WhatsApp message comes. If there is one tick, it is sent. If it's two ticks, it is transmitted. If the ticks are in blue color, it is seen by the person who received the message. But there are now softwares where without changing the color of the ticks, the receiver can see the message. The question is whether the message is seen and acknowledged. So these are the questions with the developing technology. These are the questions that are cropping up before the trial courts. So, as things stand, for a trial court and the advocates practicing the trial courts is, look at this evidence also as you look at the other evidence without suspicion. See, if a second evidence is produced, say a photocopy of a document, will you always look at it with suspicion? No, if the foundation is laid and you are satisfied that the foundation is laid and second evidence is adduced, you only argue about the weight to be attached to the evidence. The judge only looks at the appreciation and evaluation. What weight is to be attached to the evidence. That is why they say, don't look at this electronic evidence also with suspicion. Look at this evidence as you look at with any other secondary evidence. So this is how the jurists are suggesting for evaluation of secondary evidence, particularly digital evidence. Then comes stringency in bail. Reversal of onus of proof. I am discussing about confessions and presumptions. Witness protection. Anonymity of witness, anonymity of the victims. Deterrence in punishment, minimum sentences. Trial procedures, video conferencing. These are the new aspects. Witness protection, what the police force and some of the witnesses are complaining is, how long a witness will be protected? Is it sufficient if the protection is given to the witness alone? What about his spouse, college-going girl child, a son who is working in government service to be promoted? What kind of protection can be given to a witness and for how long? After the evidence is over, protection can be withdrawn. Conference commenced. And that his plea will of course continue throughout the conference. Then we must have good relationships with the partners. Somebody must, an officer from the embassy must assist us in important academic crimes in giving that certification. Because we don't know what is given to the witness when he is away and is giving evidence in a conference. We cannot also blurt out and say in the conference that he is being threatened to give false evidence or to discharge from it. These are some questions which the prosecutors and investigating officers are posing in the conferences. And these serious offences are coming up for discussion at academic level. These are some of my thoughts. I always say, now is an ocean. Horizons are ever widening, steps are untrackable. Always said these are only my opinions, my understanding of the law, within my limitations. Everybody is free to have his view, because unless we have different views and have a healthy debate, the law will not evolve. And then when each one can have his own opinion, why we discuss means, these discussions give new dimensions to our thought process and open vistas of thinking. Therefore, we always collectively think about a law which is complex, which is emerging. Thank the organizers for the opportunity. Thank you very much.